We really appreciate you guys joining in. Welcome to our fourth webinar with the NYU Tandon Future Labs and Orrick. So just as a quick matter of introduction, for some of you who have been on our webinars before, my name is Craig Wilson. I'm the Managing Director for the Data Future Lab within the NYU Tandon Future Labs. And what we are is an incubator initiative that is in partnership with NYU Tandon School of Engineering and the city and the state of New York. And our whole goal is to grow technology and entrepreneurship in New York City and state and have a resource share with NYU Tandon. So we work with early stage companies to help them grow and to help utilize NYU's resources and to help New York City and state become a hub for technology and innovation. So that's who we are. That's who I am. You can look us up at futurelabs.nyc. And we run these webinars in partnership with Orrick, Harrington, and Sutcliffe, our legal partner. They are, in my opinion, the best tech law firm in New York and probably in the country. They have an incredible practice and incredible lawyers that have been great friends and partners to us for the entirety of our time with the Future Lab, so coming on 10 years. So before I introduce our two speakers and fade off into the distance, this panel is on cybersecurity. It's the fourth panel in our New Normal series, and it is a very appropriate discussion for this week as many rulings have come down and a lot of things have happened in the past few weeks that make this an incredibly important and incredibly timely discussion. So with that, I will introduce our panelists. So our sort of moderator, or the sort of Q part of the Q&A of our discussion is Caroline McCaffery. Caroline is the CEO of one of our companies at the Future Labs. She's the CEO and co-founder of ClearOPS, a B2B SaaS data privacy and cybersecurity company. Caroline is a lawyer by training from NYU's School of Law and is a member of the bar in New York and California. And she speaks on privacy, cybersecurity, startups, law, women in business, and ethics in AI. So she is the perfect person to talk about a lot of the events that have been going on. And with us from Orrick is Shannon Yavorsky. Shannon is a partner at Orrick and a leading authority on US and European data privacy and security issues. She is based in San Francisco and uniquely qualified in California, England, and Wales and Ireland, bringing a deep understanding of the increasingly complex global privacy and data security regulatory landscape. She routinely advises her clients on a broad range of US and European data privacy issues. So with that, I will leave the discussion to Caroline and Shannon, and thank you guys so much for being here with us. Just the last thing that I would mention is that the last 15 minutes will be a Q&A for all of you guys to start asking questions. We ask you that you please direct your questions to the Q&A section and not the chat. If they go into the chat, the question is unlikely to be seen, but if it goes into the Q&A section, we will try to address as many of those questions as possible in the last 15 minutes. So thank you all for joining. I will leave it to Caroline and Shannon. Thank you guys so much, and looking forward to a good discussion.
Thank you, Craig. Thank you so much for having us, and really enjoyed being a part of NYU Data Future Labs presentation today. So we'll just jump right into it. Shannon, my first question to you is the topic on everyone's mind, which is the Schrems II decision, the case where Max Schrems sued Facebook for the second time. Would you be able to give some background?
Sure. Thanks so much, Caroline, and thanks, Craig. I'm thrilled to be here speaking today and having this discussion with Caroline. I wanted to, before we jump into the details of the Schrems decision, I wanted to lay the groundwork for the whole topic of cross-border data transfer, just to set the table here. The topic of cross-border data transfer is really fascinating. It's a mix of politics, logic, and the law that's evolved over the past 20 years. And each cross-border data transfer is like a little puzzle that you have to figure out. And every time these pieces move around, there's the Schrems decision, safe harbor, privacy shield, everything has to be reconfigured. So let me just provide a high-level overview of transferring data outside of Europe. It's a little confusing. The default rule is that you cannot transfer data, personal data, outside of Europe unless a legal mechanism is in place. And there are several mechanisms that legitimize data transfer that are the most often used. The first is standard, what are called the standard contractual clauses that I'll refer to as the SCCs. And these are a set of contract clauses that are prescribed by the European Commission, and they can't be amended except for as to their appendices. And there are three different flavors, if you will. There's an older set of what are called controller to controller clauses, a newer set of controller to controller clauses, and a set of controller to processor clauses. And I'm going to pause and just give you a little color on those terms of art. A data controller, for the purposes of the GDPR, which is the General Data Protection Regulation in Europe, the controller is the entity that determines the purpose and the means of data processing. So if you think about, I have a client that is a sneaker company, they collect their customers' data, they're the data controller. They use AWS to store the data. AWS is the data processor, and the processor simply acts on the data controller's instructions. So the standard contractual clauses allow transfers between European-based data controllers and data controllers based anywhere outside of Europe, and then European-based data controllers and processors anywhere outside of Europe. But the clauses don't really work for all circumstances, and they're pretty old, and everybody recognizes that they need to be modernized. So standard contractual clauses, keep that to one side. And then the next bucket of the next legal mechanism is countries that have received adequacy decisions. And the European Commission has the power to determine whether a country outside of the EU offers an adequate level of protection to personal data that's transferred there. And the countries that have received adequacy decisions so far are a kind of unexpected group of countries: Andorra, Argentina, Canada, the Faroe Islands, Guernsey, Jersey, Israel, the Isle of Man, Japan, and Jersey, New Zealand, Switzerland, Uruguay, and before last week, the United States of America for companies that had self-certified to the Privacy Shield. So all of these countries had received adequacy decisions, and companies in the US that self-certified to the Privacy Shield, you could freely transfer data from Europe, your EU personal data to a company in the US that had self-certified to the Privacy Shield. And this was great because it really helped companies out that were unable to use the standard contractual clauses. They didn't fit the circumstances exactly right. It was tremendously helpful. So standard contractual clauses, adequacy decisions. Then there's another mechanism called binding corporate rules. And these are a set of internal rules between groups of companies to legitimize intra-group data transfers. So for example, if you had a company in London and transferring data to its different entities all over the world, if they had obtained a set of, or gotten approved a set of binding corporate rules, then the data could be freely transferred. The issues there are that binding corporate rules take time to draft and get approved by a supervisory authority. They're costly to implement, and they don't work for all circumstances. So they're not perfect, but I do think a number of companies are going to start to rethink about whether they should go for binding corporate rules, just given all of the issues with respect to cross-border data transfer. So standard contractual clauses, adequacy decisions, binding corporate rules, and then there's another bucket of ways, legal mechanisms to transfer data, and they're called specific derogations, and they're set out in Article 49 of the GDPR. One is, and these are the most commonly used mechanisms: explicit consent. So if you get the explicit consent of the data subject to the transfer of their data outside of Europe. Performance of a contract. So where the data is necessary, you need to transfer it to conclude a contract, or compliance with a legal obligation. And this is where, for example, there's litigation in the US, they need documents from Europe. There are circumstances in which that transfer would be legitimized because it's necessary to comply with a legal obligation. I think it's really important to note that a lot of people get excited about the specific derogations. And then they think, oh, we can shoehorn everything into performance of a contract. But the Article 29 Working Party and the European Data Protection Board, which are supervisory authority bodies in Europe, Article 29 Working Party is the old body, have indicated that all of the specific derogations need to be really narrowly construed. So they're not useful in all circumstances. So what you have is a pretty limited set of legal mechanisms that don't work in all circumstances. So that's what you were working with to begin with. So now turning to the Schrems decision, the current judgment has its roots in 2013 when Maximilian Schrems, who is an Austrian law student, originally brought a complaint before the Irish supervisory authority called the Irish Data Protection Commissioner, claiming that personal data transfers under the US-EU safe harbor, which is what preceded the Privacy Shield, was unsafe. It did not provide an adequate level of data security, of protection for the data transferred to those companies that had self-certified to the safe harbor. And that led to the invalidation of the safe harbor in 2014. And then a few months later, the Privacy Shield filled that void. So companies kind of shifted from the safe harbor to the safety of the Privacy Shield. And during that time, many companies continued to use or switched to using the standard contractual clauses, or the Privacy Shield gained in popularity. But Schrems' ongoing complaint led to the Irish Data Protection Commissioner referring a couple of questions to the highest court in Europe. And in last Thursday, the highest court in Europe, mostly following the Advocate General's opinion that the Privacy Shield was invalid. It did not provide an adequate level of security or protection for personal data transferred to companies that had self-certified to the Privacy Shield. And this ruling means that businesses in Europe will no longer be able to transfer personal data to a recipient in the US in reliance on that recipient's Privacy Shield certification. And because the ruling takes immediate effect, many businesses that had been relying on the Privacy Shield as their primary justification for transferring personal data will need to think about implementing a new transfer mechanism. And as we set out before, the transfer mechanisms are pretty limited. Standard contractual clauses, and I would note that as part of the Schrems II decision, as well as invalidating the Privacy Shield, there were criticisms of the standard contractual clauses. And there's a question now as to whether certain transfers of data using the standard contractual clauses are, whether the standard contractual clauses are a valid mechanism. So out of all your mechanisms now, you have the standard contractual clauses that have been questioned for transfers to the US. You have those adequate countries. So if you're transferring data to Uruguay and Andorra, carry on. But if you were using the Privacy Shield to transfer data to the US, you're gonna need to rethink about how you're transferring data. So I think that's it's a really sticky situation for companies that relied on the Privacy Shield to be in right now, because the other legal mechanisms just don't fit certain circumstances really perfectly. And I know a lot of companies are scrambling. So this is something that really requires close consideration to figure out what the best options are. Some companies are considering whether to totally stop processing EU data, which I think is, on the sliding scale of risk, it's low risk, no EU data, no transfer. But that really, for a lot of companies, it's not really an option. But I put that out there as being like, sliding scale of risk. You're not transferring any data. That cross-border data transfer issue is obviated in those circumstances. But I think, Caroline, it's going to require companies like taking a really close look at what they're doing and figuring out where they want to sit on that sliding scale of risk.
So thank you for that background. That's really super helpful. I'm going to ask you some questions that hopefully you have some answers to, but I think they're really specific on what to do next. So to start, if you're already in the process of pursuing a Privacy Shield self-certification right now, should you abandon it?
So it's a great question. And the interesting thing is that the different regulators, so each country in Europe has a supervisory authority. And while the GDPR was meant to harmonize law across Europe, lately, in relation to a number of different things, there have been different opinions coming out from different regulators. And so it will really depend on where the company has their lead supervisory authority, to look carefully at what that regulator has said. So the UK Information Commissioner, so in the UK, has said they are reviewing their Privacy Shield and standard contractual clauses guidance after the judgment. And they've said, if you're currently using the Privacy Shield, please continue to do so until new guidance becomes available. Please do not start using the Privacy Shield during this period. So companies that are in the middle of certification, would not advise you to carry on and go through the entire process. I think that, and the only other thing I would say there is that a lot of the things that you need to do for the Privacy Shield are privacy protective anyway. So there may be not such terrible measures to look at. Like some of the Privacy Shield principles are the things that you as a startup, as a company, need to be thinking about anyway. And they're kind of good guideposts. And I think, look at those, figure out what your delta is, and just keep it in mind, but don't go all the way through renegotiating contracts to include Privacy Shield language or updating your privacy notice to include the specific Privacy Shield disclosure. And again, if you're using a particular, if you have a particular lead supervisory authority in Europe, look at what they're saying, because like I said, there are 28 different regulators in Europe, and they're saying slightly different things, which is not terribly helpful for anyone, but it means you have to look at what the regulators are saying right now.
Yeah, I think that's really good advice. I actually have an interesting question here from an attendee, but before I get to that one, I just want to answer one question that says, do you have a sense of how many institutions relied on Privacy Shield? I'll just quickly answer and say I think it's about 5,500. But the question that I want to ask you, Shannon, from an attendee is, what about de-identified data from Europe to the USA? Is that still covered under Privacy Shield, or was that covered under Privacy Shield, and so now any of those types of data transfers are also invalid? Or because of its de-identification, is it not considered personal data under GDPR?
That's a fantastic question. So the concept of de-identified data is a really interesting one. In Europe, there are two different terms of art. One is anonymized data, which means the data can no longer be linked directly or indirectly with an individual. And it's a really high bar for data to be truly anonymized for the purposes of the GDPR. If it is truly anonymized, then it's no longer considered personal data subject to the GDPR, and it can be freely transferred anywhere. But anonymization it's kind of a tricky concept. I know that in the US, we think about de-identification in terms of the definition under HIPAA that has two different ways to de-identify data, the safe harbor, taking away 18 different identifiers. It's the concept in Europe is different. And I think there's guidance that came from the old general body called the Article 29 Working Party on the concepts of anonymization and what's called pseudonymization under the GDPR. And it's worthwhile checking out that guidance to just, sort of check whether you might be meeting the threshold for truly anonymizing data, because the bar is very high. But again, if data has been truly anonymized, go for it. Freely transfer that data. It's no longer personal data for the purposes of the GDPR.
Awesome, great. Thank you for that. Okay, so back to a little bit on the Privacy Shield. Should should a company delist from the Privacy Shield? You sort of touched on that before about not pursuing Privacy Shield, and the ICO UK commissioner saying that companies who are on the Privacy Shield should stay on the Privacy Shield. But this is more about, what do you think about maybe the US and the EU reaching a quick Privacy Shield 2?
Right. So Safe Harbor 3.0.
Exactly.
It's totally possible. I mean, it's foreseeable that the European Commission will attempt further negotiations with the US Department of Commerce, which sort of administers the Privacy Shield, to explore the possibility of amending or replacing the Privacy Shield in quick order to address the perceived deficiencies that were identified by the Court of Justice of the European Union. In the interim, I feel like businesses would be well advised to identify compliance gaps in their data transfer strategies caused by the ruling and implement alternative mechanisms where feasible. If you're already in the Privacy Shield, I wouldn't actively delist. I might wait for further guidance, which I have a feeling is going to be coming out hopefully thick and fast in the coming weeks. Wait for further regulatory guidance and see what's going to happen there. I think it's such an interesting question, because when they renegotiated Safe Harbor and they implemented Privacy Shield, the fundamental issue, which was US laws that allow for the government to access personal data, didn't really go away. So for me, it was sort of in some ways a legal fiction that the Privacy Shield was this perfect replacement for Safe Harbor. That's kind of what the Irish DPC has said it, and now the European Court of Justice has said it. And I don't know if that closes the door to Safe Harbor 3.0. I think it's worth waiting to see what people are thinking about. Again, it's pretty politicized also. And the negotiations last time, they went on for months. And I remember there was this photograph that came out of when they finally, everybody agreed on the Privacy Shield, and everyone in that photo was haggard because they had been awake for days. They all had these like deep circles. And so we'll wait to see. We'll wait to see what happens there. It's again, this is why cross-border data transfer for a privacy lawyer, it's just such a fascinating topic, because it's political, it's a puzzle, and it's really shifting all the time.
It actually sort of addresses one of our questions about the potential reversal of the validity decision after the next election. And I do think that the US election will have an impact on how these things go. But I do want to go to another question. I think this is a really great question as well. I'll read it, but then I'll kind of interpret a little bit. How can the various legal mechanisms be used to manage contracts with third parties? For example, a US company doing business with a US-based vendor, but collecting information from EU-based employees. And I'll just add a little bit to that, which is, if you're doing business with a business in Europe, SCCs seem like a good alternative right now. But what if you are collecting data on your employees over in Europe? What kind of mechanism can we rely on for that?
So if you're collecting data from EU employees, mm-hmm. So the standard, I mean, if you have if you have an employing entity in Europe and you're transferring EU employee data to the US, or it's accessible in the US, then the company could consider the standard contractual clauses. Consent you can't rely on in an employment context, so that's not really workable. The binding corporate rules is an option, but again, I mean, I think there are, and I haven't checked this recently, but I think there are under 20 sets of binding corporate rules that have been approved by regulators. Again, I think people are going to start taking a closer look at binding corporate rules, given all of the invalidation of the Privacy Shield and Safe Harbor and questions over the FCCs. I think people will start looking closer at the binding corporate rules. But for a company that's just transferring employee data, I would look closely at the standard contractual clauses, so controller to controller clauses, and figure out whether those are those are workable. I think for me, one of the bigger questions, and a lot of you on my US, well, not a lot, but some of my US clients are in this circumstance where they're a US-based company. They don't have any entity in Europe. So they don't have an office, agency, branch, or any kind of stable arrangement in Europe. But they're covered by the GDPR because they have a ton of, for under that second limb of GDPR applicability, either they're monitoring the behavior of individuals located in Europe, or there is intent for them to offer goods or services to individuals in Europe. So they're advertising to people in Europe. And they can't really use the standard contractual clauses because you have to have an exporting entity. So they really relied on the Privacy Shield as their mechanism to transfer data to the US. And without it, I was having this conversation with a client that they're like, well, what about, we have all these customers. What about performance of a contract? And unfortunately, it's that derogation is really narrowly construed, and it's only supposed to be used where the transfer is occasional. And the guidance from the regulators has been that it's where, for example, a travel agent might need on a one-off basis to transfer data to someone. It's just a pretty narrowly construed derogation. So that doesn't exactly work. So we're sort of left scratching our heads and trying to figure out if they should think about setting up a European entity, but that has all kinds of tax implications. But again, there's, on one end of the spectrum, there's stop collecting data from people in Europe. And for this company, they have so much of their sales and revenues comes from Europe. That's not really workable to just totally shut the door or pull up the drawbridge, right? So then they're like, well, maybe we really need to seriously consider setting up a European entity so that we can enter into the model contract clauses, which sounds a little, outlandish, but, when you're trying to think of creative solutions and there's nothing else on the table, you're thinking through what might work.
That's really interesting. I was really curious actually about that specific issue, and I think this question from an attendee is exactly on the same point, which is, when you're talking about collecting data from users, from individuals, it doesn't seem to be a mechanism left in place that covers it. And I want to sort of shift that into, and I actually think that solution is very creative. So when it comes to your privacy policy, if you were Privacy Shield certified, the Privacy Shield required that you listed on your privacy policy that you're self-certified under the Privacy Shield. If a company, to this point of having individual users from Europe, if a company had said on their privacy policy that the data flow was permitted under the Privacy Shield, should that specific language now be removed from privacy policies?
Yeah, that's a good question. I don't think that that data should be, or that language should be removed just yet. I think that, self-certifying to the Privacy Shield, you agreed to adhere to certain principles. And those principles are things that go to show that you are providing or taking steps towards providing an adequate level of security for the transfer of data. And one thing I think is relevant to consider in this context. So what is my risk? What is my real world risk here now that I don't have the Privacy Shield? And you look at, everybody's terrified about the GDPR fines, 4% of annual worldwide turnover, 20 million euros, whichever is higher. That's why the GDPR is on the front page of the Wall Street Journal. But the regulators are bound to take under consideration, under Article 83, they're bound to take under consideration the steps that you took to mitigate risk. So if you were still taking steps to secure data, I think that a regulator would take that under consideration in levying any fine. And they're bound to take under consideration the things that you've done, the steps that you've taken to mitigate risk to individuals. So I do think that having that statement there is not going to do you harm just yet. Again, that caveat is watch this space, look for what the individual regulators are saying to make sure you know what the latest and greatest is, because it's changing on a daily basis.
So that leads me to two questions. If you have not chosen a supervisory authority, any tips on how to go about thinking through the process of choosing a supervisory authority. And then this kind of goes to a question that we were just asked, which is, and how is this gonna, is this sort of a wait and see place that we're in right now? Or how do you think that things are gonna unfold over the next few months in terms of, is there gonna be enforcement, and are we gonna start seeing some massive fines?
Right. We're at the confluence of so many things right now, globally, politically, from a privacy perspective, and from a privacy perspective. So Privacy Shield is just, blown up, right? And I think another thing that goes into thinking about lead supervisory authority is that the end of December is the end of the Brexit transition period. So and we don't really know what's going to happen there just yet. So that's when the UK is officially out of the European Union. So everything is, status quo has remained up until, the end of December. Privacy Shield, standard contractual clauses, and the EDPB, the European Data Protection Board, nothing's come out about whether the UK is going to get an adequacy decision, so that it would fall under the same, data could be freely transferred from the UK to the rest of Europe. So we don't know even what that's going to look like right now. And I have a ton of clients that are, the UK is their the ICO is their lead supervisory authority. And they're trying to figure out, okay, so what's going to happen now we don't have a lot of guidance. All of our people are in the UK because we wanted the, part of being able to have or take a benefit from what's called the one-stop shop. So being able to be subject to the jurisdiction of a single regulator, which is of tremendous value, being able to use and be regulated by a single regulator. They're wondering where to go and what to do, because you can't really forum shop, because to take advantage of the one-stop shop, you have to show that jurisdiction is where decisions are being made in relation to data. And Google had an issue with this because the CNIL, which is the French regulator, issued their, the biggest fine, I think the very first huge fine of 50 million euros that came out. And Google said, wait a second, Ireland is our lead supervisory authority. We have all these people in Ireland, and we, created this management functionality in Ireland so we could use one-stop shop and have the very, the Irish DPC is thought to be pretty reasonable, or really reasonable. And the CNIL said, no, sorry, all your people hadn't moved to Ireland yet. So we can still regulate you. And they didn't, that final judgment just came out of the highest administrative court in France and upheld that fine. So if you're thinking of choosing a new lead supervisory authority or thinking through that decision, I think it's really important to look at it very carefully, because it's not like you can just say, oh, well, Ireland, we know they're very reasonable. They speak English. It's a pretty decent time zone. Why don't we choose them? It's a lot more than that. But, writ large, the regulators that people are thinking of, Ireland, English speaking, closer time zone, the regulators deemed to be pretty reasonable, pretty business friendly. Not subject to Brexit, so you're not going to have that sort of uncertainty there. And another one is the Dutch Supervisory Authority. So they're also English speaking and known to be fairly reasonable and business friendly. But these decisions also have a huge impact on the rest of the organization, because again, to be able to show that you're making decisions in relation to data, you have to have people there. If you have people, you have a tax presence, and it impacts your tax situation. So I've interacted more with my tax people in the last few years than I ever have, because they're asking, they're trying to figure out where the European hub is going to be. So know that it has a sort of network effect, and has to be thought about pretty carefully.
Yeah, super good advice, especially considering all the costs involved with that. And as a growing company, it's one thing you're very sensitive to. So we have another question here. What mechanism would you suggest a US vendor receiving EU data from a client with offices in the US and EU use? use the SCCs? Does it matter that the client has already transferred the data to US servers before access? I'm still kind of processing that question myself. I think there's one thing to note is that if any data transfers before the July 16th decision are still governed under Privacy Shield, right? It's just anything from that date on. Yeah, so what mechanism would you suggest for a US entity receiving EU data from a client with offices in the US and the EU? SCCs?
So it's a good question. So I guess the first question is there definitely EU personal data at issue? So that being true, there is EU personal data being transferred. Does that entity have, or does that company have an EU-based entity? And if so, think through whether the standard contractual clauses would be workable and whether the US-based vendor is acting as a controller or processor in those circumstances. And then, so one of the things that people have been talking about in relation to using this STCs for continued transfers of data from Europe to the US is carrying out a risk assessment. And this comes out of the Schrems II decision as to whether that data is likely to be the kind of data that the US government would want to look at. I think we're all sort of unpicking that and trying to figure out what the risk assessment would look like what kind of data would be of interest to the US government programs that might want to access that data. That's TBD. Maybe talk to me on Friday and I'll have a better answer. But it's that's part of the decision that's been particularly challenging, I think, is, okay, we don't have Privacy Shield. And now you've said something really nuanced about, about transfers using the standard contractual clauses to the US. So I think that warrants really careful consideration. And again, different regulators are saying different things. So look at what your particular regulator is saying.
So let's shift a little bit away from the Schrems II decision. And let's talk a little bit about how startups scale for privacy and cybersecurity. I know that you are someone who's an expert in the FIPS. Thought maybe you could describe what those are and talk about how that impacts companies specifically.
Oh, okay, great. Thanks, Caroline. Yeah, so I love talking to new companies about the FIPS because it gives them a sort of framework to think about all of the privacy decisions that you're making, all of the product decisions, all of the services decisions. It really is a global philosophy for you to think through what you're doing with data. And the FIPS are the Fair Information Practice Principles, and they have their roots in sort of 1980s thinking about privacy, and they are really the architecture, the underlying, the roots of all or most privacy laws throughout the world. And so the Fair Information Practice Principles, I'm going to go through them in a little more detail. Data minimization, and this principle is that you should only collect the minimum amount of personal data that you need to achieve whatever processing you need to do. So data minimization, really important. Do you need to collect all these other data points, or do you just, I know there's this tendency to go like this and collect as much data as possible, but carefully thinking through whether you need all of those data points. So data minimization. Data quality, so making sure that the data that you're collecting is accurate, complete, and kept up to date. And that can be fairly challenging, but it's good to keep in mind that data is kept fresh. The purpose limitation principle, so only using data that you collect for the purpose for which it was collecting, not collecting it so that you can fulfill an order and then you're like, oh, I quite like this data, I'm going to use it for marketing and maybe for improving all my products and services, really only using that data for the purpose for which it was collected. And generally that should align with what you've told people that you're collecting it for. So making sure that it aligns with what you've told people in your privacy policy. Another principle is data security. So personal data should be protected by reasonable security safeguards against risks like unauthorized access, destruction, use, modification, or disclosure of personal data. Really, really important principle. data security. We're going to talk about that in a little bit more later, but data security is critical. Transparency, so there should be a general policy of openness about data practices and policies with respect to personal data, making sure that you're telling people what you're doing with the data, how you're using it, what you're collecting, who you're sharing it with. And then the accountability principle. And these principles are part of the GDPR, the 7 core principles that underlie the GDPR. And they also inform the California Consumer Privacy Act, the new CPRA, which is the CCPA 2.0. So they're really, really important because they're the pillars of a global privacy compliance program are built upon these fundamental privacy principles. So when you're a startup and you're thinking about how you're treating data, I really encourage you to use this framework for thinking through what you're doing with data. So again, I'm going to go through them, just recap: data minimization, data quality, keeping data up to date, purpose limitation, data security, transparency, and the last one is accountability. So making sure that you are accountable for complying with measures that give effect to these principles. For me, a really core part of the accountability principle is papering your decisions, papering your analysis. Even with respect to Privacy Shield, so the Schrems decision, if you're making a decision to carry on, not withdrawing from the Privacy Shield or making a decision to switch to another method of cross-border data transfer, paper it, memorialize your thinking, and that is going to help you from a regulatory perspective. If a regulator comes knocking, you're able to say, yeah, you know what, we thought about this and these are the reasons that we made this decision. And that's going to go a long way to helping you in the future, and even anyone looking back on why something was done. Like, why did you switch from Privacy Shield to standard contractual clauses? Did you carry out a risk assessment on the kinds of data that were being transferred? So accountability is really, really important. I highlight that from, especially from a startup perspective, making sure you're papering those decisions so that anyone who's moving out of a privacy role into something else, someone else can pick up and be like, oh, here's the privacy story. I see what you were thinking. I see what was happening here. And again, so from an internal, just management, data governance perspective, it's great. And then from a regulator facing perspective, litigation perspective, it's also really, really important.
Yeah, I couldn't agree with you more that being organized and keeping records is really your best friend when it comes to privacy and cybersecurity. It's actually what we are one of our main foundational feelings at ClearOPS and why we built what we were building at ClearOPS. But I want to actually, this kind of takes me to a question that was asked first in the panel today, which is, if you look at FIPS as the foundation, and to your point where it is the foundation for GDPR, for CCPA, for New York Shield, which is what the question asked. If you build your privacy and cybersecurity program looking at FIPS as guidance, does that mean that you're going to be at least on the right path towards complying with all of these various laws? And so, because to your point earlier, there's just so many laws, and even GDPR is also up to the individual member state. So if you're looking at FIPS and you're using that to build your program, are you really taking the best steps you can forward in being ready for all these different laws that apply?
Yeah, I really think so. So I think that building a privacy principles-based program is critical for demonstrating a credible global privacy compliance program. There are 120 countries that have privacy laws, and all of them have at least shades of these principles. So if you're building from the ground up, having these principles, building your program based on these principles is going to put you in a very good position vis-a-vis consumers, building trust as a business, regulators, litigants, activists. I think that being able to show that you built your program on these really established core principles of privacy and data security is going to help you to mitigate risk globally. And I think that, that in conjunction with accountability, keeping everything, as Caroline said, really organized is going to be so helpful for you as you scale as a business. And I recommend at Orrick, we have a global privacy compliance program called Privacy in a Box that is essentially like a virtual, I don't know if they would like me saying this, it's like a virtual binder. So it's like with little, like in my mind, it's, I'm known from the 90s talking about binders with like little tabs that you're able to say, oh, okay, this is what we're doing for cross-border data transfer. This is our written information security policy. Here's our privacy but by design policy. Here's our data map. Like having all those things in one place that are built on these principles, like different chapters of your privacy story, is going to put you in a great place as you scale as a company.
So we have a question, another question from one of our attendees that I think is worth asking and really interesting. What to do with data that I no longer need? 2 examples. Initially needed the data, but no longer as the company has matured. That's 1. And then 2, the data that was not necessary, but was part of the boilerplate terms of service. Do you have any thoughts on data deletion and data retention, frankly?
Yeah, definitely. So that's data lifecycle is really important to think through. And certainly data that's no longer required should be discarded. And there are different ways of doing that. In the US, there are many different state laws that speak to the manner in which data should be deleted. The CCPA and arguably the GDPR allow you to, the CCPA allows you to de-identify data in response to, let's say, a deletion request. So you can credibly sort of delete data. And if it's no longer required, then it's no longer, you're no longer falling within purpose limitation, right? Because you no longer need it for the purpose for which it was processed. So it should be discarded on a regular basis. It's kind of a tricky concept in some ways because there are so many different laws that require you to retain data for certain reasons: employment law, property law, tax law, that say different things about how long you're meant to retain certain documents, which may include personal data. So developing a policy with respect to data retention is really important to be a sort of cross-functional policy, the development of that policy that will figure out really more precisely how long you definitely need to keep certain documents based on applicable law. But it's a great point and a really, really important one, storage limitation, making sure you're not storing things for longer than is necessary. And Caroline, I'm sure you would say from a security perspective, the less data you have, the better off you are in a data breach scenario. So it's helping you in a lot of different ways if you have a good developed document retention, data retention, storage limitation policy, and you're discarding it or deleting it in line with applicable law.
Yeah, and I will say, having drafted data retention policies using a law firm like Orrick to help would certainly be advisable because they do touch on so many different laws. I mean, you're even talking about contract law, right? And lawsuits and how long you have to retain for statute of limitations purposes. These are all sorts of things that are hard to think about when you're drafting a policy that you need some guidance on. So let's talk a little bit about privacy policies for a second. I know it seems like a boring topic to a lot of people since they're sort of something that most people skip over and don't read. But I personally believe that privacy policies are extremely important. And I have talked to a lot of startups specifically about where they get their privacy policy, how do they draft one, all these sort of questions about what should be in it, how much disclosure do they need to give. Do you have maybe some practical tips for the companies who might be listening?
Yeah, definitely. So I think the key thing to bear in mind is say what you do and do what you say. So if you're, that means being transparent about your data collection and use practices. And the main features of a privacy policy are telling people who you are, and what the policy applies to. So it applies to our website, our collection of information via the website, what information you're collecting. So we're collecting contact information, we're collecting payment card information, what you're using it for. So we're using it for fulfilling our, to provide our service. We're using it to comply with applicable law. We're using it for marketing, if that's the case. So being really specific about what you're using it for. The key there, or the art of it, is figuring out where you need to draw the line, like where you are able to draft it broadly enough so that your company can scale with your data collection practices. So you don't go back and look at the privacy policy and say, oh shoot, we didn't say that we were gonna collect that data. But figuring out exactly how to calibrate that, I think, is really important and definitely warrants a lot of attention to what data you're collecting, what you're going to use it for, who you're sharing it with. And you're allowed to be a little bit general. So in the who we're sharing it with section, you can say we're sharing it with service providers without listing out all the different third-party service providers. But being careful about crafting that language so that it will reflect what you're actually doing, but also enable you, thinking about scalability. I think it's also important to, make sure that you're complying with, the laws that are prescriptive about what needs to be included in a privacy policy. So your contact us section, how you make changes to the privacy policy. But the really important thing is saying what you do and doing what you say. And that's where, the FTC is really active in unfair and deceptive practices. So Section 5 of the FTC Act is where they look at a company's privacy policy and they say, well, you didn't say that you were doing this with data. So, and that's where companies can get into a lot of trouble. I would also advise companies not to cut from another company's privacy policy, because I have certainly seen that, and I've seen the some like not great editing where they left in the name of the other company and then posted that privacy notice. So it doesn't exactly, it doesn't reflect what you're doing as a company. So it really warrants paying careful attention to what you're actually doing, your actual practices, and making sure that there's a clear reflection there. And I think that's the best advice I can give you is to say what you do and do what you say. Work with a privacy lawyer to make sure that you're crafting the language accordingly so that you're hitting the, you're complying with the law, but you're also giving yourself that like flexibility that's permitted by applicable law. Noting that there are nuances if you're covered by the GDPR, if you're covered by the California Consumer Privacy Act. There are specific disclosures that are required under the different disclosures that are required by the CCPA and the GDPR. So working with counsel to make sure that you have everything in there that needs to be in there from a GDPR, CCPA, or whatever other privacy law you're subject to is included in your privacy policy. The other thing I would say about that is just noting that the privacy policy is just one place where you can make privacy disclosures. Think about other places where you're collecting data from people and making sure that you have disclosures there also.
Oh, and I would just add, making sure that your privacy policy doesn't have a date on it from 5 years ago.
Totally.
Keeping it up to date is really important for people like me who look at that date and think, yeah, that's not good.
Yeah.
We're getting short on time. I was gonna ask you about the increasingly popular security page that companies have been using recently. But before, if we have time, I'll go back to it, but we only have 3 minutes, and there seems to be two last questions here that are somewhat related. And it's going back to the Schrems decision and privacy policy and how US companies can collect data. And specifically on this one, it's just back to that question of, if you're a US-based company and you maybe have a sign-up form and you don't know, an EU citizen could enter data into that sign-up form. You're not specifically targeting EU citizens, but they certainly can enter data into that. You're storing it in, let's say, AWS in the United States. Or you have other just data that you do get from EU customers. Is putting up an SCC, like a standard contractual clauses, a DPA, data protection agreement, on your website and say, hey, if you're entering data directly into our system through a sign-up form or whatever, this is going to govern that. Is that something worth considering, or what would you suggest?
So for this question, I think there are two things that I would highlight. One is whether the company is subject to the GDPR in the first place. So the GDPR only applies to their two real limbs of applicability. So companies that I think of as having boots on the ground. So office, agency, branch, or stable arrangement in Europe, salesperson, covered by the GDPR. The second limb is where companies are not based, they don't have any office or stable arrangement in Europe, but they offer goods or services to people in Europe, and there's intentionality there. Recital 23 of the GDPR talks about where there is a website that's simply accessible from Europe, not being covered by the GDPR. So I think it's really important to think through whether the GDPR actually applies. And if I've seen companies have clients that are worried about, Europeans entering data into their website, so they geofence it. So they are able to not allow people from Europe to enter data into the website at all. And that really, helps them to, sleep easy at night, rest easy that they're not collecting any EU personal data. They shut down any kind of cookies for Europe, but they still have, informational website accessible from Europe. Clearly, in those circumstances, absent other factors, not covered by the GDPR. So I would say that that is really important in the first instance to consider whether the GDPR actually applies.
That's great advice. All right, so we're at the top of the hour. Shannon, do you want to put in maybe in the chat your contact information in case anybody reaches out to you? I'll do the same. I'll send out my email if anybody wants to talk to us. But then
Sure.
Thanks for having us, Craig. And it was a really interesting discussion.
Thank you, guys. It was an incredibly interesting discussion. Thank you again. For everyone who's on, thank you guys for coming. Look out for our next series. And we will eventually be posting the video for this, so it is an evergreen conversation, because I think it is one that people can refer back to. There's a lot of incredibly interesting information in there that I think will serve you guys who are on the conversation well, and those who might find it thereafter. But thank you all so much. And I hope everyone has a great rest of their day. Shannon and Caroline, thank you again.
Thank you.
All right.
Thanks so much.
Bye, everyone.
Take care.
Bye, everyone.